Like, oh, it's just so on. Everybody is cheering.
What's the story?
It does. This is revision. You just figure out. Your face, although.
It's
You'll
same
upload it
thing,
work and you're like, no, it
same
worked,
order,
it's just changed.
same steps. I just want to make it easier to read.
Scotty, are you being complicated mornings?
I'm very fussy.
I know this.
Unmute. Recording.
Good morning. It's 10 a.m., May 21st, 2026. We're at DPSST conference room, the time for the Police Policy Committee. Before we get started, I'll read the Police Policy Committee administrative announcement. This is a public meeting, subject to public meeting law, and it will be digitally recorded. Deliberation of issues will only be conducted by the Policy Committee members unless permitted by the chair. Remember to always state your name for the record. For cases dealing with denial or revocation, only information contained in the staff report can be considered once the staff report is adopted. Assumptions, outside knowledge, or personal experiences should not be included in any discussion. Individuals who engage in disruptive behavior that impedes official business will be asked to stop being disruptive or leave the meeting. Additional measures may be taken to have disruptive individuals removed if their continued presence poses a safety risk to the other persons in the room or makes it impossible to continue the meeting. I forgot to introduce myself. I'm Scotty Downey.
And we're actually doing self-introductions now, if you'd like. And since you already introduced yourself, Chair, Vice Chair Cotting, would you like?
Casey Cotting, Oregon State Police.
Thank you. Member Daniel.
Mark Daniel, representing Oregon Association of Chiefs of Police.
And then online, we have Member Duncan.
Michelle Duncan, representing Oregon State Sheriff's Association.
Thank you. Member Hensman.
Warren Hensman, Oregon Chiefs Association.
Member Livingston.
Teresa Livingston, Oregon State Police.
Member Lofgren.
Patricia Lofgren, public member.
Thank you. Member Wood.
Robert Wood, representing the public.
And Member Willetts.
Samuel, it's non-management law enforcement.
Now for staff introductions, Juan Lopez, Executive Assistant, DPSST, and we'll start with our Deputy Director online.
Catherine McAlpine, DPSST.
Thank you.
Victor Sanchez, DPSST.
Melissa Langbacho, Professional Standards, DPSST.
Cindy Park, DPSST.
Maria Atwood, DPSST. Jennifer Howell, DPSST.
Sam Tang, DPSST.
Thank you. Did everyone have a chance to review the meeting minutes from our February 19th, 2026 meeting? If you did, is there any changes, modifications? None. We'll look for a consensus, show of hands, thumbs up to approve as they were posted in your materials. Any objections? Seeing none? Move the minutes. Now move to administrative closures, and I'll call in Professional Standards Case Manager to present.
Thank you, Chair. Melissa Langbacho, for the record, the department reviewed 2 cases and is recommending administrative closure in those cases. They're on a consent agenda for the committee's consideration today. The department is seeking a vote from the committee to approve or return the cases for further review, Mr. Chair.
Thank you. Any questions or discussions regarding the proposed administrative closures?
Just have Casey Cotting for the record, just one minor correction. It's Caleb with a B.
I saw that on the consent agenda that I spelled it. Yes.
But I was calling him all these years. Thank you for pointing that out. There's no other questions or modifications. We're looking for a motion to approve the consent agenda as presented, or as modified, I guess, with one small correction.
Mark Daniel, for the record, I move to approve.
I'll second.
Voting on a motion to approve the administrative closures consent agenda as presented, notwithstanding any modifications. Chair Noun.
Aye.
Vice Chair Cotting.
Aye.
For Daniel.
Aye.
For Duncan.
Aye.
Member Hensman.
Aye.
For Livingston.
Aye.
Member Lofgren.
Aye.
Member Wood.
Aye.
And Member Willetts. Motion carried.
We'll move to the professional standards case review. Back to you.
We have 3 officers here today. Which one would you like to review first? Just going
You can go in the agenda order. I'm fine with that.
Anderson.
Anderson first. Yep.
Great.
Good morning.
Morning.
I'm Scotty Nowning. I'm the chair of the Police Policy Committee. Before we get started, could you identify yourself and have the other folks in the room identify themselves?
Yeah, I'm Tyler Anderson.
I'm Julio Vidrio, one of the Jackson's attorney.
Kristen Curtis, other attorney.
Thank you. You will have 5 minutes at this time to share any information you would like for the committee members to consider during our deliberation of your case. Your 5 minutes will be timed by a clock that you'll have ability to see right here. I will stop you at the end, right at 5 minutes. I'll stop you. At the end, we won't be able to ask you any questions. You won't be able to ask us any questions. And then when you're done, you can either sit at the table or you can go sit back by your attorneys, whichever you'd like. You understand that?
Yep.
Okay.
Point of order, doesn't she?
Yes.
So same. Yeah, I just give it instructions. Yeah.
Melissa Langbach, for the record. Chair and committee members, the department opened a professional standards case to review Tyler Anderson's termination from the Jefferson County Sheriff's Office. Anderson grieved his termination, which resulted in a settlement agreement. Anderson's termination stemmed from findings that he was untruthful on his application with the Jefferson County Sheriff's Office, his contacts with a disreputable person, and his failure to disclose all of his prior drug use during the pre-employment process. District attorney's offices in Jefferson County and Crook counties reviewed the investigation from Jefferson County and conducted a joint Brady investigation, obtaining additional records. The Brady investigation concluded that Anderson engaged in a pattern of dishonesty and determined that he would not be utilized as a witness in either county. Anderson is currently seeking employment as a sheriff in Jefferson County. The department identified moral fitness violations in this case. Dishonesty. Anderson was intentionally dishonest by untruthfulness, omission, deception, or misrepresentation when he failed to report his Idaho residence and employment with the Parma, Idaho Police Department on his Jefferson County background application. Anderson was intentionally dishonest when he omitted from his applications with the Oregon State Police and Madras Police Department his employment with the Parma Police Department. Anderson omitted his prior cocaine use from his application with the Oregon State Police. Anderson was intentionally dishonest about his communication with a confidential informant, stating that he sent her one message on August 1st, 2024. For misconduct, the department identified that Anderson's Brady determination created an inefficient operation in the Jefferson and Crook County District Attorney's offices and the Jefferson County Sheriff's Office by impacting the ability to prosecute criminal charges. The department is seeking disposition in the case from the committee. And just for the record, Mr. Anderson provided written mitigation materials, which are included in the committee's review packet. And he's here today to provide a mitigation statement for the committee. I also wanted to note that on the department's memo, I believe they're wrong. Date, sorry. I will scratch that information. Mr. Chair, back to you.
Thank you. Whenever you're ready, whenever our timer's ready.
I'm ready.
Okay, you can go ahead and do your mitigation.
So there's a lot of information to go over, but I'd like, a lot of people in here have done investigations. I'd like you guys to look at that. This investigation was not complete. None of the witnesses, my background investigators, or members of the public that we've asked to be interviewed were interviewed. The investigation led to the point where it seemed like I was being dishonest and stopped. So I definitely made mistakes by leaving that stuff off my application. But when it came to the actual background and got interviewed by the background investigators, I recalled the Parma Police Department and told them, Madras Police Department background investigator went to Parma, saw where I lived, and spoke to the police department. The Oregon State Police background investigator was also told by me that I left that off my application and spoke to the Parma Police Department. They have no record of me at the Idaho Police Department. It was a volunteer position. There is a volunteer until you attend the Reserve Academy, and then you can become a reserve. It was about a month and a half, 2 months into my volunteer that I was let go from Parma Police Department when I was 21. I think it was 2003, 2004. If you look at all the, I don't know how many of you guys got the transcripts or not, but there's transcripts. I've never hid evidence from the informant. I was interviewed on it and handed over my phone and gave all the text messages on the 2 dates that me and that, who they call an informant, had communication. I took a polygraph on this what they call deception of hiding my volunteer position off my applications and passed that, showing I did not try to deceive them. I've never been a drug dealer or purchased any drugs, as they say. I tried cocaine twice in college, and it was a stupid decision. I've never hid that. I've been up in front and honest with everybody on that. It was an oversight on me leaving it off. I told the investigator that that was off when I was asked about my drug history. It wasn't anything I was hiding. I understand how important it is to have a high level of integrity and how important it is to always be honest. During my arbitration investigator, we asked the investigator if he caught me in any lies, and his answers were no, but the answers were confusing, so he assumed they were lies. To me, that is not a fair investigation. I've dedicated 17 years and countless hours away from my family to serve the community. I was a respected member of the Central Oregon law enforcement community. I was a detective on the Tri-County Major Crime Team, an operator on the Central Oregon Emergency Response Team, and assisted with highly visible cases in all the agencies in Central Oregon. I would not risk my career over something so minor. I've made plenty of mistakes during my time as a sheriff or as a deputy, but I've always admitted to them. Like I said here, I made a mistake by leaving that stuff off my application, but that's why we have a background process. And I've told all the background investigators about this. They would have never known because there is no record of me in Idaho of being a volunteer there if I did not tell them. That's how they found out. So I've never hidden that. I'm just asking that you guys look at all the evidence that we've provided. The DA, the sheriff, everyone has gone off of the sheriff's office report. The sheriff has admitted himself that he never even read the report. He said that at arbitration before they settled. The investigation in my mind, is not a complete investigation. They tried to find me guilty and they stopped at the evidence that found me guilty instead of completing the investigation. I'm just asking the board to not revoke my certifications. After 17 years, I've had a good record. I've never been accused of lying on the stand, lying in a report, or lying to during any testimony. Sorry, that's all I got.
Thank you. Now I'll look for a consensus to adopt the record as it was presented. We could get the folks online to turn their camera on or give me a thumbs up or a high five or something. So we can, okay. No objections? There's a consensus to adopt the record. We'll now discuss aggravating or mitigating factors. Reminder that you need to state your name, the record, and identify whether your point is aggravating or mitigating.
For the record, I'll add aggravating is the district attorney's Brady determination and conclusionary statement.
It's got it down to the record. I'll kind of piggyback on that. It was actually two separate district attorneys as well. Looked at it from two different counties.
Timberlake, for the record, I'll add for mitigating the time served, his in-person testimony, and the letters of recommendation.
Thank you.
Deborah Wood, for the record, in addition for mitigating the polygraph self-agreement to take such the positive results of that. I'd also like to mention that not only the written testimony, the video of the FBI interview, I watched body language and it was extremely relaxed. Not like anything was being hidden at that point. So I would offer that as mitigating as well.
Right now, for the record, maybe it's more of a little bit of a concern on the polygraph. I saw the polygraph didn't address the drug use. So either it wasn't included or it wasn't included, and wish it was. Or it was, the results weren't as favorable. I don't know. I can't speculate on that, but I wish that would have been included. Other aggravating, like,
Aggravating, here's the Livingston for the record, aggravating is, even though he mentioned that, he makes mistakes, there's multiple, opportunities. And then he repeatedly left out information from background to background, at different points in time. So if you forget on one, think that you would remember to do it on the next one.
Member Wood, for the record, on aggravating, there seems to be a flavor, a consistency of either forgetfulness or differing recollections. We have testimony that he quit Parma, and then one of the records is he was terminated. We have two separate interviews. One was Josh Roth and one was Barry Wilson, who had almost identical statements about Mr. Anderson's helping package and weigh cocaine for sale. I find it concerning that they would each have that testimony, and I don't see a motive for doing such other than telling the truth.
And well, it's for the record, I'm going to just kind of jump off of Member Livingston's comments. In the OSP background, it seemed like there was a comment made about he left off Parma because he knew that it would have been a negative result, but concerning as well.
Scott, adding to the record, I think it's aggravating leaving off relevant police experience when you're trying to get a full-time police job. Seen this board or this committee has seen these type of cases before, and historically people leave stuff off that they don't want people to see, not things that make them look good. And then during the mitigation was saying there was no record of him being in Idaho, but in the packet there's clearly a record of his notice of termination from Parma Police, and code of conduct that was signed, and several documents. PSST was clearly able to get those records.
Mark Daniel for the record. Aggravating, I keep coming back to the F5s and F7s, and when asked in multiple occasions, have you ever been discharged for cause from a public safety agency? It was marked no repeatedly.
Member Hensman, aggravating. When I thought about this and leaving out the Parma Police Department, that would have been the first thing I would have put on as experience for any job. I know that young people today try to get experience as a cadet, as a CSO, a variety of different policing careers, and that would have been on the top of my mind to put on any application.
I think for the record, I'll just add that in a lot of the areas of omission or fail to declare, it's surrounding something would have a negative impact. So whether it's employment based, moving on in a process, that struck me as aggravating.
Michelle Duncan for the record. Under the misconduct, I also found the inappropriateness of him telling this quasi-informant the status of another person who was also possibly working as an informant. That's, highly inappropriate in that setting.
Anyone else aggravating or mitigating?
Member Wood, for the record, a minor aggravating thing that I struggled with is the cell phone, the 20 plus messages on one day, that the reason given was there was a photo they kept trying to send. And the answer was he deleted the photo to stop that instead of just deleted the text, which was it's minor, but it's just one more instance of something just not making sense.
Anyone else? Okay, would you like to review?
I missed Vice Chair's statement, if you could.
Yeah, what I found aggravating is that when there's an omission or something not disclosed, it would result in a negative impact or stopping the process in which Mr. Anderson was in, whether it's disclosure of drug use or past employment.
I have as reported as mitigating that his time working in the profession, his verbal mitigation and written statements, the polygraph and the video from his FBI interview were mitigating. And then as aggravating, the Brady determination and conclusion, there were two district attorney's offices in 2 counties that placed him on the Brady list. The polygraph did not include questions about his drug use. He mentioned in his verbal mitigation statement today that he made mistakes and he had the opportunity to correct those mistakes, but continued making them. There were consistent inconsistencies in his statement. And there were 2 officers that had the same testimony about his packaging of drugs while he was in college.
Can I interrupt you 1 second?
Yes.
I think those are witnesses, not officers.
Okay. 2 witnesses had the same testimony about packaging drugs. In his application with the Oregon State Police, he left off his employment with Parma because he knew the result would be negative for him. To leave off experience in the profession, in the profession that he was seeking a job was aggravating. DPSST was able to obtain records from his employment in Idaho, so there is information that exists. It was aggravating that he left off of his applications with DPSST, that he was discharged. And there was information that he should have included when applying. His omissions and information that were not disclosed would have stopped the employment process. His contact with an informant was inappropriate. And the cell phone text messages, where there were 20 plus messages that were sent, his explanation that he deleted a photo doesn't make sense, Mr. Chair.
Thank you. And we need to open discussion about the moral fitness violation categories identified in the staff report. In this case, it's dishonesty and misconduct. Our options are to affirm, modify, or negate. And we'll have discussion if we need it, or we're looking for a motion to affirm in a second. Motion in a second.
Member Willetts, just for the record, go back to the summary. I think we missed the letters of recommendation for mitigating.
Oh.
I just want to make sure we have it all.
Thank you.
Thank you. I do have the written mitigation and the letters. Okay, thank you.
For discussion or motion?
I'm gonna make a motion to affirm. The dishonesty and misconduct.
Daniel, for the record, I'll second.
We're voting on a motion to affirm the moral fitness violations as presented. Chair Nally.
Aye.
Vice Chair Cotting. Member Daniel.
Aye.
Member Duncan.
Aye.
Member Hensman.
Aye.
Member Livingston.
Aye.
Member Lofgren.
Aye.
Member Wood.
Aye.
And Member Willis.
Aye.
Motion carried.
We're looking for a motion and a second to take action or take no action. Please remember to state your name and record the supporting reasons to take action or no action. This is just to take action, not the actual period of time if action is taken.
Member Wood, for the record, I'll make a motion to take action.
Sam Willis for the second, or for Sam Willis for the record, I'll second.
Voting on a motion to take action. Chair Nally.
Aye.
Mr. Cotting. Member Daniel.
Aye.
Member Duncan.
Aye.
Member Hensman.
Aye.
Member Livingston.
Aye.
Member Lofgren.
Aye.
Member Wood. And Member Willis. Motion carried.
We need to discuss the ineligibility period. In this case, it involves dishonesty, which is 3 years to a lifetime, and misconduct is 3 to 10 years. So see the dishonesty would cover up to a lifetime. Make sure you state your name and have discussion about why you're recommending the amount of time you're recommending.
Michelle Duncan for the record. I would vote for lifetime on the dishonesty and misconduct. Since it'd be a combined, I think there were multiple offenses. And he did not take ownership of any of it.
Livingston for the record, I second.
Voting on a motion to impose an ineligibility period of a lifetime. Chair Nally.
Nay.
Vice Chair Cotting. Aye. Member Daniel.
Aye.
Member Duncan.
Aye.
Member Hensman.
Aye.
Member Livingston.
Aye.
Member Lofgren.
Aye.
Member Wood.
Nay.
Member Willis.
Nay.
Motion carried.
That thank you. Oh.
Next.
Can you go get Mr. Lazot? Yes. Budworth?
We're just going in agenda order. That's how it was on the agenda.
Here,
It was easier to make
this
this.
is wonky.
Got it.
Give them the instructions and wait.
I was confused. So
I wrote
sorry.
wonky on that, wonky. You give them the instructions, you're like, but I don't see anything.
But I'll
for a
see.
while. Not now. It's not bad. Thank you for backing me up. Thank you for seconding that. Thank you. Juan, can we get a
I'm like-
motion and a second? This is wonky.
That's the time person I got confused for. Yeah.
It just, well, like I said, we'll just put these in different order. It'd be great. Good morning. My name is Scotty Downey. I'm the chair of the Police Policy Committee. If you could identify yourself and whoever is with you.
I am Derek Lazot. I'm the police officer for the LeGrand Police Department, and with me today is Daniel McGuire. He is in support. He's with Tribal Police.
Thank you. Let's review the case first.
Okay. Melissa Langbacher for the record. The department opened a professional standards case to review a criminal charge that was self-reported by Derek Lazot. reporting from the incident indicates that Lazot shot a deer and used his stepson's hunting tag. Lazot was convicted of a misdemeanor wildlife violation and was sentenced to bench probation, community service, and a hunting license suspension for 3 years. He was granted an early termination of his probation. In the department's review of the incident, moral fitness violation was identified as misconduct. Lazot violated criminal law and has a misdemeanor conviction for a wildlife violation. Mr. Lazot provided written mitigation, which was included in the committee's packet, and he's here today to provide a statement to the committee, Mr. Chair.
Thank you. So after I give you the instructions, you'll have 5 minutes to provide the committee with mitigating information. At the end of that 5 minutes, we won't be able to ask you any questions, and you won't be able to ask us any either. And I'll stop you right at 5 minutes as well. We'll have a timer that you can see. So make sure you plan your mitigation accordingly. After you're done, you can either sit at the table or you can go sit in the back of the room. It's fine either way. Understand that?
I understand.
Okay. Whenever you're ready, start the timer.
Good. Before coming here, I read the same mitigation letter that I've sent to you guys over and over and tried to get it under 5 minutes, and I realized that's not going to happen. I took my opportunity to come out in front of you today and just open up. I made a mistake. I took my son hunting, and I was with my daughter as stepdaughter. And it was his first time hunting. It was going to be his first animal he was going to be able to shoot. And he just wasn't able to do it. He asked for help, and I did it. I knew better, and yet I let emotions take over, and I made a mistake. It was reported, it wasn't reported by myself to OSP, but it was reported to by their biological father. As soon as I found out, I made sure I made my sergeant and admin aware of the situation. I was completely honest with them. I did not try to hide anything from them. And I did my very best to be as open and compliant with them to go through the process. Through the lengthy process that I endured, it was quite eye-opening to see what people that we deal with go through all the time. I like to believe that when the trooper came to my home, I treated him with the utmost respect and was honest and compliant. Through the facts of the case, I just would like it to be known that I did not in any way try to tell my children to hide the fact that I was the one that shot it. I didn't try to spin the story or try to get them to tell anybody else that Kaysen actually shot the deer. When it comes down to it, this process has been, like I said, very eye-opening. And I can honestly say I've learned my lesson, and I will never be putting myself in a position like this ever again. This process was very grueling, and I learned my lesson. All I ask is that the committee, when you guys do make your decision, I ask that you take a look at what I've provided you, my history with the police department and my community. And I ask that you not revoke my license so I can continue to provide a service to my community. That's all I have.
Thank you. We're looking for a consensus to adopt the record as presented. No objections? Record is adopted. We'll now discuss aggravating or mitigating factors. Remember to state your name and state whether your point is an aggravating or mitigating factor. And I'll start, Scotty Downing, for the record. I thought the letters of support were compelling, especially from who they're from, from the sheriff and the chief of police, folks who I think have good standing in the community and are putting their name out there in support of this person, potentially at their own risk. That's compelling to me and mitigating.
Livingston, for the record, mitigating factor is he was forthright and honest throughout the investigation and was cooperative and took ownership of his mistake.
Sam Willis for the record, I think for mitigating, his testimony today was very heartfelt and forthcoming, and I think he took ownership of it.
Scotty Downing for the record, mitigating also, obviously released from probation early, went through the court system, was given probation, was released early, which means he was complying with all the conditions of the probation, doing everything he was supposed to be doing.
I think for the record, I'll add for mitigating is that the frequency in which we see fish and wildlife offenses in this committee, this one stands out where there was ownership and complete honesty about the case from when it was brought forward through the court process. So that I find that mitigating.
I'll also add to that, and to his cooperation through the investigation of just having everything available to the trooper who's doing the investigation.
Patty Lochran, for the record, I'm speaking as a former classroom teacher. If I were in that situation, I probably would have made the same mistake, helping one of my students to achieve something that he had never achieved before. So to me, that seems like, yes, it was a mistake, but I feel like I would have made the same mistake.
For Hensman, mitigating also, I felt the need to share. I believed everything that he said. And I don't think I've ever seen an opportunity to be demoted to a non-sworn position with the potential to be reinstated. I think it says a lot about the individual officer and type of person we would want serving our community.
Any other aggravating or mitigating? Or we have Melissa review? I'll wait, I'll stall while you're writing.
But for the record, we get letters of support quite often. But I think my recollection is this is the first time we actually received a letter of support from the acting sheriff, which I think speaks volumes to the support that Officer Lazot is getting.
Melissa Langbasher for the record. I didn't hear any aggravating circumstances, but recorded a number of mitigating ones. The letters of support were compelling. He was forthright and cooperative. He took ownership of his mistake. His verbal mitigation was heartfelt. He took ownership of his actions. His probation period was ended early. The case stands out amongst other wildlife violation cases, and they took ownership and cooperated with the police officers. He provided everything needed to the officers during the investigation. His mistake was to help a child and was something that was understandable. His agency's decision to demote him was indicative of his good standing with the agency. The acting sheriff's letter of mitigation was compelling and showed support for him. Mr. Chair.
Thank you. Need to now affirm, modify, or negate the moral fitness violation categories. And in this case, there's only one misconduct. We're looking for a motion and a second.
Robert, for the record, I'm going to make a motion that we do affirm the misconduct because it did occur.
Downing for the record, I will second.
Voting on a motion to affirm the moral fitness violation as presented. Chair Downing.
Aye.
Vice Chair Cotting.
Aye.
Member Daniel.
Aye.
Duncan.
Aye.
Member Hensman.
Aye.
Member Livingston.
Aye.
Member Lofgren.
Aye.
Member Wood.
Aye.
And Member Williams.
Aye.
Motion carried.
Now we're looking for a motion and a second to take action or take no action. Remember to state why you're making that motion.
Let me stand for the record. I say we take no action. The mitigating factors are pretty overwhelming, and the support from the community and his law enforcement community.
Scotty Downing, I'll second that and add that the courts punished this individual. He did everything that was required. And so I think the punishment has been served. So I would second that.
Voting on motion to take no action. Chair Nowlan. Mr. Tripani. Member Daniel.
Aye.
Member Duncan.
Aye.
Member Hensman.
Aye.
Member Livingston.
Aye.
Member Locker.
Aye.
Member Wood.
Aye.
And Member Williams.
Aye.
Motion carries.
Thank you. The press on? All right.
All right, you, still.
We're ready. All right, just switched up your whole deal. Does this play?
There's a little bit still of a delay, but yes.
It is.
Right, stand first or?
I'll just ask you, thank you. My name is Scotty Downing. I'm the chair of the Police Policy Committee. After your, or if you could just identify yourself and who's with you.
Oh, my name is Corey Budworth. This is Aaron Schmaltz. And I turn your name.
Thank you.
Yep.
Once we present the case, then I'll talk to you about a mitigating statement.
Great, okay. Melissa Langbacher for the record, Chair and committee members. The department opened a professional standards case to review Corey Budworth's criminal charge for assault in the 4th degree. Criminal charges stemmed from an incident at a protest on August 18, 2020, in which Budworth, while on duty, pushed a photojournalist to the ground and hit them in the head with his baton. Budworth's criminal case was dismissed following a restorative justice process, which included a public apology to the photojournalist. Budworth's employer, the Portland Police Bureau, reviewed the incident and determined that his use of force was out of policy and issued him a letter of reprimand. The department reviewed the information and identified moral fitness violations in the case as misconduct. The department identified that his conduct physically and emotionally harmed a photojournalist documenting a protest in Portland. His conduct harmed the city of Portland, resulting in a civil lawsuit payment of $50,000. His use of force negatively impacted the efficient operation of the Portland Police Bureau by threatening the relationship between the Portland Police Bureau and the community it serves. Budworth provided written mitigation, which is included in the packet for the community's consideration, and he's here today to provide a statement. The department is seeking a disposition in the case from the committee.
Thank you. So you will have 5 minutes exactly to provide a mitigating statement. There'll be a timer here that you can see. At the conclusion of your mitigating statement, we can ask you any questions and you can ask us any questions, and I will stop you right at 5 minutes. And then once you're done, you can either sit at the table here or if you want to sit in the back, it's fine with us. Doesn't matter.
I don't think it'll be 5 minutes, but yeah.
Okay.
Read my phone.
Whenever you're ready.
I appreciate it. Committee members, thank you for letting me speak today. This is not something that comes naturally to me. I'm fairly a quiet person, and talking to myself in a room like this is pretty difficult. I wrote this down because I wanted to be thoughtful and respectful for what I say. I'm here today as a police officer, a husband, and a father who made a mistake nearly 6 years ago.
I'm not here to argue or minimize about it. Regardless of the chaos of the moment, and regardless of my intent, my actions resulted in harm. I take that seriously. I have taken it seriously from the beginning. That is why participating in the restorative justice process was so valuable. It gave me the opportunity to listen, take responsibility, and apologize to Ms. Jacobs. It also gave me a chance to reflect deeply on my role as a police officer and the trust this profession requires. I accept the written reprimand imposed by the chief. Since then, I've continued serving at City of Portland and working to show through my conduct that I learned from this experience. I currently serve uniform patrol as an acting sergeant and am on the promotion list for our next one. I'm actually the next one up. I mentioned that not to praise myself, but I believe it reflects the trust my department continues to place on me. I know one event can stay with a person for a long time. This has stayed with me. It forced reflection, humility, and growth. I've tried to honor the growth through the way I serve, the way I lead, and the way I carry myself as an officer. I do not take for granted the privilege of wearing the badge and the responsibility that comes with.
We're looking for a consensus to adopt the record as presented. Any objections? Record's adopted. Now discuss aggravating or mitigating factors. Reminder, state your name, and if your point is aggravating or mitigating. I'll start, Scotty Downing for the record. I thought was very mitigating the numerous amount of letters of support and who they were from. Oftentimes we see letters of support from the officer's parents or someone who we'd expect, but this is from district attorney, the chief of police, command staff from the chief of police, peers. I felt that to be very compelling and very mitigating in this case.
Connie, for the record, I'll add today's testimony was mitigating as well.
Mark Daniel for the record. I just want to add that not only is it from the serving district attorney at the time in regards to the restorative justice, but also the district attorney today, as well as Chief Day. And those were significant documents for me.
Got it down for the record, the fact that he went through this process of restorative justice, he had to make a video or did make a video, apologize. It was out there for the world to see. I can imagine it's been 6 years of just this thing that just will not seem to end. And it seems that, mitigating for me is that he served ample punishment for that misjudgment.
Sam Willis for the record. I think you guys have covered all of my points. I'll just add that he was given leadership opportunities from within the department. He's now a sergeant and on the promotion list to go up.
So mitigating also, I think one of the letters was from the baseball coach who talked about his volunteerism for years, volunteering to serve the youth. And so I found that as mitigating as well.
Robert, for the record, the only aggravating thing is there was contact to the head face with a baton. But however, mitigating against that, watching the video, slowing it down, I truly believe it was not intentional. I think it was accidental. She was getting back up, it looked like. And I believe what we have here is a policy violation. I don't think it's a use of force violation. Well, it's a use of force violation as far as their policy goes. But in addition, it was a very tumultuous time. I think it was Ms. Jacobs. She had press pass on, which is interesting because I remember that allowed them to get behind the line. But clearly she was involved in what was going on. And so I can understand Budworth's action that he took.
Member Hensman, mitigating for me, and something I'm not used to, clearly thinking back to time we faced a few years ago, but reading about the tactics that people use during demonstrations and just trying to put myself in that position as a reasonable police officer. I just wanted to share that as a mitigating because I did appreciate the tactics being explained on paper that other people use during these demonstrations.
Anyone else aggravating or mitigating?
Okay, most record, I'll throw out there, the memo from the command staff, I don't remember which one it was, but who went into detail about the gram factors and the situation that he had been hit in the head. He'd been exposed to pet OC spray, and he witnessed what he thought was an unarrest happening. I think, while yes, it was a chaotic time, and he, in his verbal testimony, said that he's not going to rely on that as facts. I think that that should be taken into consideration because all of that comes into play.
Just clarify that's mitigating.
Mitigating, thank you.
Yeah, remember Wood, to expand upon that, in taking the totality of the circumstances, he had someone running at him during that veered off at the last minute.
Remember, has been mitigating, if I recall correctly. I think he was ordered to leave anyway. That's correct.
Connie, I'll add for the record, as mitigating just the genuineness of the testimony and how the officer conducted himself throughout the restorative justice process. And that it felt taken very seriously. And I think the community really appreciated that.
Got it.
Ready?
Ready.
Okay.
Want to review?
As aggravating, I believe the only thing I heard was that he did make contact with the photojournalist's head. And then as mitigating, specifically to mitigate that, his contact was not intentional. Also as mitigating, I heard that there were multiple letters of support, and those letters of support were from district attorneys, chiefs, and peers, and they were mitigating to the case. His verbal mitigation today was mitigating. The restorative justice process was conducted publicly, and he was punished publicly for his conduct. He's currently on the promotion list. His baseball coach and community service for that is mitigating. At the time the event occurred, there was turmoil in the city, and his actions were understandable. The tactics that were explained, that the tactics that were being used and his actions that were explained were mitigating. The memo from command staff where they believed an unarrest was happening, although it is not what was happening, should be considered as mitigating to the case. There were people running at Officer Budworth. The crowd was ordered to leave, and how he conducted himself throughout the process was mitigating, Mr. Chair.
Thank you. Looking for a consensus that this has captured our aggravating and mitigating. Anything else to add, missed? There's consensus. We now need to have discussion about whether or not there is a moral fitness violation, options to affirm, modify, or negate, and it's only misconduct.
Yeah,
Yeah,
what
we'll
is the record? Did I just interrupt you?
It was me, but it's all right.
I would propose that we strike the misconduct. As I said earlier, I believe this is a policy violation and an intentional policy violation. So I don't believe there's a moral fitness violation.
Conversation about that or a second?
Michelle Duncan, for the record, I'd second that. I think with the totality of everything going on, I don't know that this was a use of force violation.
Have a motion in a second.
We're voting
Negate.
on a motion to negate the moral fitness violation as presented. Chair Nowning.
Aye.
Vice Chair Connie.
Aye.
Member Daniel.
Aye.
For Duncan.
Aye.
For Hensman.
Aye.
Member Livingston.
Aye.
Member Lofgren.
Aye.
Member Wood.
Aye.
And Member Williams. Motion carried.
Thank you. Yeah, 10-minute break.
What's that?
Sure. Well, we're gonna take a 10-minute break. Yes.
Let me go ahead and hit record. Okay.
Okay, it's 11:07. We're back on the record. The next item on the agenda is, if we're going by this, criminal justice fee implementation. Chris Enquist, take it away.
I am not Chris Enquist. In his stead, I'm Joe Staub. I'm a skills training manager here at DPSST. And I'm filling in for Chris, who is over at the OSSA conference in Central Oregon today. So back in, I'm sure you guys all knew this from your notes, but back in December of 2025, I've pressed the board to look at the possibility of implementing a fee structure for some of the regional training that we do and some of the use of this facility by constituent agencies. The board asked that we do a little bit more research, conduct a study, just a survey of agencies to find out how they would react to this, and then to run it by each of the individual policy committees and see if we could get endorsement to take it back to the board. So just to be clear, today's endorsement or non-endorsement is not saying yes or no to the fee implementation. It's giving us the option to go back to the board with the fee structure and things that we've come up with here. So the idea of the fee structure really is coming from the costs primarily in regional trainings when people don't show up to the courses. So when we have, we have 20 seats, 30 seats, whatever it is for a firearms IDC or use force update, whatever it is that we're running regionally. We have people assigned to those seats. We send a correct number of instructors to get our student to instructor ratios correct on the range, all that type of stuff. And then if we have people back out of that at the last minute, those instructors are already there. It's still, we're still paying the money to have instructors training regionally when we could have done it with fewer instructors. The original idea was to start charging a nominal fee to agencies when they sign their officers or deputies up to come to the trainings. After conducting our study, the idea of a fee-based process for attending the courses was not very well received. Better received by agencies was the idea of a no-show fee, right? So if you sign up your student to come to this training, and at the last minute, 72-hour window was our kind of last minute. And if at the last minute you had to pull your student out, there was going to be a fee paid for having withdrawn from the course at the last minute. So that's what the registration fee has been turned into as a no-show fee. On the local side here at DPSST, currently the facilities use contracts that we use allow us to recuperate costs if a specific damage has occurred, right? If somebody's using the village for some kind of building clearing training and they break a window, we can charge that agency to replace that window. So specific things like that can be charged, but just general maintenance, wear and tear on things like the track and the building, the fire hall towers and those types of things, there's no mechanism to recoup any of the money from just the wear and tear of use. So the facilities use fee structure, that's the idea behind that one, is that obviously facilities wear out faster the more you use them, the more often we have outside agencies coming here to use things like the track and the other training venues that we have, the building. So we came up with a structure and fee structure, depending on which facility you're using or which training venue on campus you're using. There would be a daily use fee, basically. I think you guys have the copy of the study that has the fee structures and things in there. Is that accurate? Okay. So, and just to summarize the kind of the feedback from the survey itself, we talked about the idea of the sign up fee for regional trainings. That wasn't super well received. They did prefer the option of a no-show fee. We also have built in the option for a waiver to the fees if it's going to be a significant financial hardship to your agency to send somebody with or to come use this facility with the fee structure that we've built. There would be a waiver process where you could apply to use it without having to pay that fee. Yep. So if you guys were to endorse this idea, we would take it back to the board in their July meeting and again, present this to them and see how they feel about it. There would be obviously legislative process that would have to take place post board approval. So this actual implementation of this fee structure wouldn't take place for probably a year plus to get through the process. If this committee chose not to endorse, that would basically just be telling us and telling the board that this is not something we think is good for constituent agencies out there. And we would start looking at other options for ways to fund, ongoing maintenance on campus.
Scotty Downing, for the record, am I reading right? On the survey, roughly 50% of the comments were against the fees. Is that all the fees or just?
Yes.
Sound like that.
Yeah, so roughly 50% were concerned that the fee might be an issue for them from a financial standpoint, right? They would create a hardship for them, and that they would probably use that waiver route if it were an option.
Scotty and I, for the record, I guess my concern is there's lots of organizations and places you could send folks to pay for training. Many agencies use DPSST because it's where you can send them and not necessarily pay for training. So I think getting in the business of pay for training, you're going to put yourself in a whole new level of competition, although this seems starting out very inexpensive, but there are lots of training courses out there and all sorts of places that charge to go to. So maybe misguided.
Can I jump in, Marie Atwood, for the record? Are you talking about the fee for on-campus usage? Or regional fee?
So this is only if you, well, I guess it's both. So the EBOC track, like $200 a day.
Yeah.
Is I'm saying, so there's other places that also teach EBOC or.
Right.
Or CBU.
And you can correct me if I'm wrong, Joe, but my understanding of the proposed fee implementation would be if it is not DPSST putting on the training, but an external agency just needing to use the facility for their own non-DPSST purpose. So
Right.
DPSST's trainings are still free to those who need them if they're sponsored.
And that's my point. But I think a lot of agencies, at least local agencies, come here and use this facility rather than sending their folks somewhere else and pay for training. So that's a good risk to lose that.
Rob Wood, for the record, as a non-sworn trainer who happens to work for the regional team, I can tell you how frustrating it is when we set up a class and we have to limit it not only because of the range itself or the classroom, but because of safety instructor-student ratios. And there's a waiting list, which I don't think, Joe, you mentioned. There's always a waiting list. Sometimes it's 4 and 5 people long. And it's just happened in Bend. I was tasked with calling the person that didn't show, and he said, "Oh, I thought someone was going to call you. I can't make it." At that point, the class is starting. It's impossible to call someone from the coast to come over to Bend. So I personally believe the late fee is not aggressive enough. And we talk about a deposit that would be refundable, so that way they would make sure the agency would pay for it. Is there no vehicle for doing that?
So that was an idea that was floated at one point that didn't come out in the final version or the original version that was presented to the board. Something along those lines could certainly be looked at some points, but the place that we landed was not charging any fees up front, no deposits, no anything. You would only have to pay a fee if you withdrew at the last minute.
And that's right down there. That makes sense to me. Paying if you don't show up because.
But is $100 enough? That's and I know this has gone through lots of discussion, but I think we need to encourage people to either show or give the product notice that they can't show.
What happens if they don't pay?
That's
collections. And collections. Send state police.
Marie Atwood, for the record, I know at least in the discussions I was a part of the conversation involving paying in advance and then getting kind of refunded upon completion, or what do we do if someone doesn't pay for the no-show? Some of these concerns are a little bit due to like the lack of a logistical mechanism for DPSST to start collecting. We're not a collection agency, so we'd have to really take a lot of steps to obtain either software or some sort of fee collection system to do things any other way besides a no-show. This is the simplest way to incentivize arrival when you say you're going to be there, or a modest penalty if you're not.
And then you're probably going to have to hire someone to manage this fee collection system. And right.
Member Hensman, just a comment. I don't really see an issue with utilization fee for the facility. Upkeep's expensive, wear and tear, and sometimes police officers, and I assume everybody else that's here. You know, I'm not gonna say they treat the place rough, but you know, we put it to work, I would imagine. So I don't necessarily have any issue with a fee in that sense. I know in my own city, I'm charged a square footage fee, so I'm kind of used to it, I guess.
Michelle Duncan for the record. I also do not have an issue with the utilization fee. I think that especially, like, I know the track is extremely difficult to book, and you have some agencies that use it a lot more than others. And they're more responsible for that wear and tear. So that fee would kind of like equally disperse that to the agencies using it.
Bonnie, for the record, I think I appreciate the look at this and the survey and trying to land at what would be supported by the law enforcement community. And I think it's fair. I think the problem you're describing is something many agencies face internally, and we usually try to curb it with, you know, low-level corrective action and go from there. But it is really disruptive. And when that is your day job and your business, like it's taking away from other people. So really, we're impacting the agencies they work for, but then the agencies are going to turn around and manage their officers a bit better. So I support that.
We need a motion to move this to the board.
Probably a consensus
Yes.
motion.
Action at Maria Atwood for the record, action item on the memo is to review and recommend that the agency proceed with the fee approval process to the board. So basically presenting similar information to the board for consideration. So motion and vote on that.
Mark Daniel, for the record, I make that motion. To move the proposal from DPSST to the full board.
Member Hensman, second.
We're voting on a motion to approve the criminal justice fee implementation for facilities and regional as presented. Chair Nani.
Aye.
Vice Chair Connie.
Aye.
Member Daniel.
Aye.
Member Duncan.
Aye.
Member Hensman.
Aye.
Member Livingston.
Aye.
Member Locker.
Aye.
Member Wood.
Aye.
And Member Wood.
Aye.
Motion carried.
Thank you. Moving on to proposed rule changes for OAR 259-008-0085.
Thank you, Jennifer Howell, for the record. For this agenda item, DPSST requests that it be tabled for a later meeting. It needs the accompanying curriculum proposal for the subject hour breakdown to proceed the rule change. So that did not make it in time to your packets.
I can grant that, I'll grant it. Do I have the authority to do that or?
No. Yeah.
Granted.
So it just records that it was on the agenda, but moved to a later meeting. Thank you.
Let's move on to 0300. Zero 0310.
Thank you, Chair and members of the committee. Jennifer Howell for the record. This agenda item presents additional recommended changes for Administrative Rules 259, 008, 0300, and 0310. Both of these rules were included in the comprehensive set of proposed rules related to moral fitness standards and the processes that we use for denying and revoking certifications when that major packet was presented to you in February. Since then, staff have identified two additional areas where the language within the rules could be clearer. And today I'd like to walk you through those two issues and the proposed amendments that will help align the rules more closely with their original intent. Well, I'll just keep going. The first issue involves how we handle student conduct at the academy. Right now, the rule gives DPSST fairly broad authority to open a professional standards case based on any violation of the student conduct standards, even if the student wasn't dismissed from the academy as a result. That is a bit broader than what was originally intended. It also creates confusion on who's making the determination that a violation occurred. The proposed change that's in your memo is straightforward. We're limiting these discretionary cases to situations where a student is actually dismissed under Administrative Rule 259-012-0035 for a conduct violation. This accomplishes two things. It places the responsibility for determining whether the student conduct was a violation with the training division and not with compliance staff. It narrows the grounds for opening the professional standards case to situations where the dismissal occurred. So if the dismissal is appealed by the student and overturned by the director, then it's no longer a dismissal, therefore no longer grounds for a professional standards case. And that was one of the gray areas that we wanted to clean up. If the dismissal does occur, it is a violation, then it moves over to the compliance staff for a determination on whether or not there was a moral fitness violation. This brings the rule back in line with the original purpose and removes ambiguity for both staff and for students. The second issue relates to employment arbitration. Under the current rule, our handling of professional standards cases is tied fairly closely to what the arbitrator finds. But as we've worked through cases, it became clear that there is an unintentional limitation to the independent authority of the department, the committees, and the board to determine moral fitness. So the proposed rule changes remove the prescriptive outcomes that are currently found in the administrative rule. And instead, they'll clarify that the arbitration findings may be considered, but are not the determination. So in other words, employment decisions such as a reinstatement or an arbitrator's view of the underlying facts do not control the moral fitness determinations. And here are some key points. DPSST will be able to stay a case while the arbitration is happening. That's our current practice, and we would continue that forward, and the administrative rule would maintain that authority. Once the arbitration is complete, we would continue reviewing the case under the usual processes that are found in administrative rule. And if an arbitrator orders reinstatement, we would continue to treat the matter as a discretionary professional standards case. And in following that process review that's found in rule, it would come to the committee as appropriate. That could be through an administrative closure or through a discretionary case where you make findings. DPSST recommends approval of these two rule changes, and the memo that you have includes a fiscal impact statement. That fiscal impact statement identifies that we did not find a fiscal impact as a result of the rule changes. So we often recognize that anytime someone is denied or revoked, it impacts the individual and it impacts their employing agency, but those are pre-existing conditions. So we didn't find anything that was new or unique about the rule changes. Process-wise, if the policy committee votes to approve the proposed rule changes, we're going to submit the proposed rule changes to the Secretary of State for the public comment period. And then we already plan to come back to the committee in August with the revisions that we're making to that larger package of moral fitness rule changes. So what we'll do then is after the public comment period, we will merge these changes with that large package of changes. And you're going to see that package in totality again in August for final review and approval before submitting to the board. I would be happy to answer any questions, but otherwise you have action items on page 5. Thank you, Chair.
Thank you. So it says a consensus or a vote, or a consensus and a vote?
Consensus on the fiscal statement, and then motion and vote on the approval of the proposed rule changes.
Right. Probably, since there's no fiscal impact, starting down for the record, I think we could probably look for a consensus to approve that as prepared. So if we have a consensus, action item 1. Does anyone have any comment, or do they want to make a motion in a second to approve the changes as presented? Writing down for the record, it made sense to me. I would make a motion to approve it.
Sam Reynolds, I'll second.
Voting on motion to approve the proposed rule changes for Oregon Administrative Rules 259-008-0300 and 00800310. Chair Noun.
Aye.
Mr. Cardin.
Aye.
Member Daniel.
Aye.
For Duncan.
Aye.
For Hensman.
Aye.
Member Livingston.
Aye.
For Lochner.
Aye.
Member Wood.
Aye.
And Member Willis.
Okay, moving on, still with Jennifer, to a whole bunch of changes starting with 259-008-005, all the way through 00400.
Thank you. Chair, members of the committee, Jennifer Howell for the record. This agenda item facilitates review of the comments that were collected for the proposed rule changes relating to the moral fitness standards and denial revocation processes for criminal justice public safety professionals. For the record, the proposed changes were for Administrative Rules 259, Division 8, the numbers ending in 005, 290, 300, 310, 320, 330, 340, and 400. So DPSST presented the proposed rule changes to the policy committees during the February 2026 meetings. Each policy committee provided feedback that DPSST collected as part of the comment process. Following the policy committee meetings, DPSST held a public comment period from February 26th through March 31st, 2026, and DPSST received one written comment. Your memo is arranged in two parts with supporting attachments for reference, if needed. The attachments provide the written comments and a copy of the proposed rule changes as they were presented in February. Part 1 of the memo is summarizing the comments from all three committees from February, and no action is requested today on Part 1. We are already in the process of incorporating the committee feedback into revisions to the proposed rule changes. As mentioned before, those revised drafts will return to the policy committee in August for review before they go to the board for final approval. So we're looking today at Part 2 of the memo, which covers the single written public comment that was received. Staff summarized the comments and provided an interpretation and an analysis in sections A through F. The action item is outlined on page 4 of the memo just before the summary and the analysis of the comments. The committee can either adopt DPSST's recommendations regarding the written comments, and that would mean no additional changes beyond what's already provided in Part 1. Or if you feel that any part of the written comment should lead to a rule revision, you can make a motion to include those specific sections for consideration when we bring the August draft back to you. Chair, thank you. Return it to you for discussion and happy to take any questions.
Catch up, sorry. And so you are looking for a motion from us on this one?
Yes, DPSST is seeking feedback on whether or not you want to accept DPSST analysis as provided in the memo, or whether or not there was something in the written comment that you would like to have explored further.
Member Willits for the record. Looking at number C, the emergency suspension, the DPSST recommends conditional or considering additional review. Can you kind of walk me through, is that more review from us? Is that more review in total? I mean.
Certainly. So when we presented the emergency suspension, there was feedback from the committees. And so we already have feedback from the committees that we're looking to incorporate. So let's see, the comment said, I think that the comment was primarily about it gave permission to do emergency suspension, but did not require it in certain situations. And the initial proposed rule was written that way because we were looking at a broader scope of conduct that could result in that emergency suspension. Based on some of the committee discussion, we would be looking at a narrower focus on what would trigger an emergency suspension event. And with that adjustment, then it may become something that is a automatic outcome. If this, then that, if it has that narrower focus. So it's kind of still in development, and we would be bringing it back based on the committee feedback.
And member Willetts again. So for when it says consider additional review, if we take action on this, I'm assuming you'll bring it back with said additional review?
Yes.
Okay.
All of the changes are coming back in August for another look.
Okay. Thank you.
Can I interject?
Absolutely.
Marie Atwood, for the record, for the emergency suspension section, it's also important to note that the comment we received was essentially suggesting we consider broadening again the scope of what someone could be emergency suspended for and how soon they could be suspended. So, for example, the rule proposal, I believe, in our initial draft was if someone is indicted for a specific list of very significant crimes. However, the comment suggestion would be enforceable at the time of arrest, right? Which is a bit of a lower bar for proof requirement. So that would be among the items for possible consideration if the committee would like us to engage in further discussion and review of the comment suggestion.
But we wouldn't do that today. That would be something. So it would come back to us again.
We'll come back to you no matter what. Yeah.
But if you have feedback and direction on what we should be including in what we bring back to you in August, then that would be helpful at this time.
Member Willetts, I think the way that DPSST has it established now is appropriate. I don't think that the comment through suggestion to broaden it is necessarily appropriate.
For the record, I think it may be solving a problem that doesn't exist because someone gets indicted for a very serious crime. I can't imagine any police agency keeping them working.
Sure.
I just think that would be. Yes, of course, I guess it's the head of the agency who keeps himself working, but. And I guess from the comment is our understanding, that's the problem they're trying to solve is if there's this major crime this person has committed and they still have their certification, even though it's a practical matter, they're not utilizing it.
Correct. It's even though a person may have been put on a leave of absence, when you look at the DPSST records, they show as employed and certified. And this would be allowing, so as proposed, and it would be in your attachment B, DPSST presented to you it is page 17, that after being notified of a charge, DPSST would submit any supporting documentation to the board's executive committee for review, determine whether there's a serious danger to the public, to allow the person to retain their certification while everything is in process. So the emergency suspension immediately suspends the certification before we can go through the denial revocation process.
Clarify, that's how.
Pardon me?
That's how it is now.
That is how we proposed the change. So we don't currently exercise emergency suspension unless it's being presented to the committee for that. So this is, so there are two parts. We're maintaining what we already do. So if we came to you with a discretionary case today and you said this person cannot walk out the door and continue to have their certification, we recommend an emergency suspension to go into effect now while you're finishing out the denial revocation process. That's what's in the administrative rule right now. And then what we presented in February was an expansion of that. So when we're notified of a charge. So when we have the unfortunate incidents of an individual who has been charged with severe crimes, being able to take action on that immediately, even before we have put the case together to bring. bring to you. So we'd be bringing it forward to the executive committee for that authorization.
99 for the record, that's a temporary suspension.
Emergency suspension is temporary. It's effective immediately. It doesn't require any prior notice. It just goes into effect immediately once it's been approved by a body. And then it remains in effect until either withdrawn or until the final order revoking the certification is complete.
So if additional information came up that showed this person maybe did not do that, they could.
Yes.
Return.
So the recent example, there was potential for community harm because the individual was not in custody. So in an incarceration example, we would still just do it regardless, even though they're incarcerated, pending charges.
Right.
We would still do this.
It gives the authority to. Right now, it's a May issue. And so what we'll be determining what to bring forward in August is whether or not that narrows, if we're narrowing the scope, because it's right now, it is charged with any crime that would be a felony under our mandatory standards. And that's fairly broad. And the committee feedback that we had was that perhaps to reduce the discretion from one case to another, different outcomes being subjective, that perhaps we could look at narrowing that, not to just any felony crime, but maybe major person crimes or the Measure 11 crimes. And then if you're looking at that narrow focus, then what may be considered is whether or not does it need to come to a committee for approval, or if it's that narrowly focused, is it just something that DPSST does? So those are the different changes and nuances that we would discuss in August, with sample language for you all to be able to review and choose from.
And stuff for the record, with that kind of further description, I definitely agree with Member Willits about the comment section, like I wouldn't want to go broader to like just being arrested. To keep it a little bit more stringent.
Michelle Duncan for the record. I think just with the case we even just heard, where he was indicted, I mean, if the DA said his baton was potentially a deadly and dangerous weapon, like even an indictment or an arrest, without all of the whole story, I think it could be a potentially dangerous road for us to go down. So I would say if we use it, we're going to have to be really cautious in how we use it in that way.
Member Wiltz again, just to kind of get off of that comment, just to clarify the process, if somebody gets indicted and it comes to DPSST for review, DPSST wouldn't automatically issue the suspension. It would come before a committee.
Yes.
So, okay.
Yes. Right now, it comes before a committee, and then in the proposal that was presented in February, it would be submitted to the executive committee of the board, which is available for those emergent things that come up between board and committee meetings.
Okay. Thank you.
Still a May.
Still a May issue an emergency suspension.
So the discretionary issue is falling upon DPSST. Decide if there's a community threat or an element of this case that should come to a committee.
Jennifer, for the record, in part, yes, but in the proposed rule change where it's currently stating that it would be anytime someone's charged with a felony, that would probably be the time that that would probably indicate to staff to bring it forward to determine whether or not, to have the executive committee determine whether or not there is a threat or harm to public safety. And then if based on the previous comments from the committee that were more narrowly focused, that would also make it an easier process to bringing it forward to the executive committee for review.
Yeah, Marie Atwood for the record. I'm kind of jumping off of what Jennifer just stated. Our goal in the proposed rule, as we've drafted it currently, is not to kind of place or give any undue discretion to DPSST to be that decision maker. But if there's a really narrow set of cases where arguably there should be a decision made about whether to emergency suspend or not, it gives us a clearer pathway and a lot better picture of which cases should go to a committee for that decision. So we wouldn't be the people exercising discretion over who does and does not warrant an emergency suspension. But if it falls into that narrow bucket of cases, that those are the ones we take to committee to decide, does this warrant an emergency suspense or not?
And Scotty and I, for the record, the executive committee is comprised of
Jennifer, for the record, each chair of all of the committees. So the Police Policy Committee, Corrections Policy Committee, Telecommunications Policy Committee, Fire Policy Committee, Private Security Policy Committee, and the chair of the board.
I think for the record, I would maybe propose that we look for language that would narrow this. Like if it's at any felony crime, it's a bit broad. We've seen cases here where an individual's charged with felony crime and there's really no belief there's ongoing community threat. Like it was a one-off situation with a known person. We don't think it's gonna carry on. Versus victims. The person's out in the community. We believe there's likely to be more victims. Like if we can articulate there's an ongoing community threat, I believe that is the cases we would like to see. But there's plenty of cases that come through here that are at the felony level where I don't think we would want to be making that determination without the full record.
I mean, we learned that picking up a rock in the national park is a felony. And so we did learn that, mandatory arrest. And so that's where I think, to your point, we have to be. Well, and I like that there is discretion, obviously, still. So yeah, it's a loss to what we're doing, supposed to be doing. I'm ready to make a motion to do something.
Sure. Based on your conversation about what the comment suggested, you would recommend no changes related to the comments. And then as discussed, when we're coming back in August and we're incorporating the policy committee feedback from February and the discussion today, we'll be presenting some revisions to the proposed emergency suspension process that also incorporate a narrower triggering events and circumstances. Yep. So if you didn't have any other questions, and you're welcome to have more questions and discussions about other parts of the public comment, but if you don't, then it would just be motion to take it as written from DPSST staff regarding the comments.
For the record, I think DPSST adequately answered the public comments, and I would make a motion to this forward.
Daniel second.
Voting on motion to approve the review of the public comments for the proposed rule changes for OAR 259008 with serial ending 0005, 0290, 0300, 0310, 0320, 0330, 0340, and 0400. Chair now. Vice Chair Cobb. Member Daniels.
Aye.
Member Duncan.
Aye.
Member Hensman.
Aye.
Member Livingston.
Aye.
Member Lofgren.
Aye.
Member Wood. And Lindsay. Motion's here.
Thank you.
Next item is applicant review committee nominations.
I'll take that one, Marie Atwood for the record. So we have, obviously PPC gets 2 spots of representation on the applicant review committee. One of our current members, Rob Wood, is facing the end of his first term on the applicant review committee. So today, assuming that Rob still wants to be on the applicant review committee, would be the day for us to renominate him to continue in that position.
There's no other open positions?
No, not right now.
Does anyone else want it?
We've all heard you do a great job. Word on the street.
I'll make a motion that we nominate Rob.
I would enthusiastically second that.
Voting on a motion to renominate Rob Wood to the applicant review committee. Chair Nally.
Aye.
Vice Chair Cotty.
Aye.
Member Daniel.
Aye.
Member Duncan.
Aye.
Member Hensman.
Aye.
Member Livingston.
Aye.
Member Locker.
Aye.
Member Wood.
Abstain.
And Member Will. Aye. Motion carried.
Let's try. And moving on to agency updates.
Okay, we'll also take some of those on. Marie Atwood for the record. I guess to jump off on a similar note, we also have a few members of this committee whose first term is going to be expiring, all of whom I believe intend to continue serving on their second term. We don't need to do anything on that today, but I do just want to thank members Nowning, Daniel, and Lofgren for your first successful term on the PPC, and we hope to see all of you again for your second term. Updates from the agency. There's a lot going on right now. One thing of note is the significant amount of progress we've made since the last time this committee met in our procurement of a learning management system for the training division. So we had hired a program manager to begin that process, and she has done a mountain of work and moved at light speed. As I'm sure many of you know, the process of procuring something at the state level is glacial, to say the least. And she's done a really great job of trying to get us some momentum built so that we're not waiting, years down the line to get this learning management system up and running. So the update that I have on that is that we have officially gotten our Stage Gate 1 endorsement and moving into Stage Gate 2, which is project management terminology for we're past the initiation and information gathering phase into the resource identification phase. So figuring out what collection, I suppose, of companies or vendors we're going to be potentially sourcing our learning management system from. If and when we get that figured out, then we'll proceed with the actual procurement of the system itself. Simultaneously, we are also pursuing a legislative concept for 2027 that involves adding a few staff to DPSST's roster for the purpose of kind of getting the program up and running and staffing its continued maintenance and making learning management system a really groundbreaking part of how we deliver training. It should hopefully give accessibility to a lot of regional constituents who just can't come to DPSST all the time for things like maintenance. And it should make everything from enrollment through certification a lot more streamlined and simplified for all of our new officers and public safety professionals who are here at the Academy. Other agency updates. We have a whole lot of campus projects going on right now, which I'm sure you've seen some of. Our B building has a large-scale roof renovation happening right now. We just got our memorial lights replaced. They look great. The F building, of course, is going through a major renovation because it's been described to me that if the wind blew too hard, that whole building would fall down. So really grateful that those are up and running. Our facilities and operations team has done an enormous amount of work to make sure that our deferred maintenance budget and our kind of repairs budget is correctly ordered in terms of priority for what's kind of at the code red level for this 20-plus-year-old agency that hasn't had a ton of renovations since the day it was built. Some things are definitely more pressing than others, and they're doing a great job to keep those balls rolling. We are also at the end of June and a couple first days of July doing a parking lot repaving project. So luckily, we're planning to have it complete during the time that we're in down week period. So there shouldn't be a ton of students or people who need parking around. It's also part of holiday week. So that should be helpful in facilitating that. And on the note of our memorial lights being replaced, we did have a very nice ceremony for the Fallen Officer Memorial a couple of weeks ago. And on June 16th, we're doing our Fallen Firefighter Memorial. So if you're interested in attending that, we would highly encourage it. Other updates, legislative concepts, in addition to our learning management system staffing proposal, we're also pushing forward a few legislative concepts that are relevant to this group and to our other committees and our board. One of which is we are asking the legislature to have us adopt a new category of board membership for tribal membership, so that we can have adequate representation in these conversations, because the work we do here is pretty important, and the discussion that our committees and boards engage in is really critical to anyone in the industry. The other significant legislative concept that's moving forward, that's relevant to this group especially, is because we are once again pushing to have deferred cases available for us to exercise jurisdiction on for moral fitness violations. So when I say deferred cases, I mean those cases where a moral fitness violation may have occurred, but the person is no longer employed with their agency. We, at this time, do not have jurisdiction to do anything about those a lot of the time. And they have been piling up in a fairly large backlog and sitting in limbo until somebody new wants to hire this person. It creates a really difficult situation for us because we just can't process anything. We're kind of stuck in the mud, and it also creates significant hurdles for the public safety professional who's in limbo, because they may not get hired because they would have to declare that there is a pending or deferred moral fitness case against them, and they can't gain any traction in further employment. So that proposal would allow our policy committees and our board to have discretion and jurisdiction in deciding those moral fitness cases, either in an effort to engage in denial or revocation of that person's licensure, or to take no action and let them move freely forward with their career in public safety. Another big update for the agency is our efforts toward accreditation. So we are pursuing accreditation through IATList. It's going to be a really good sort of national scale stamp of approval on the excellent work that our training division does here at the Academy. We're actually pursuing two different rounds of accreditation. The first is going to be really particular to the training division, and then the second level of accreditation will move into our post, so our professional standards division. We are doing an enormous amount of internal auditing of all of our practices in the training division to ensure that everything we're doing is meeting national standards, that we're adhering to evidence-based practices. And after we're done with our internal audit and submit, our request for accreditation, we then are subject to an on-site audit by IATList to facilitate our approval. So we will keep all of our committees and our board posted with any updates in those processes. Let's see here. One update for this group in particular, I'm sure many of you know because we were frantically emailing about availability, but we are going to have a special meeting of the PPC to hear a case that we were not able to have on the record today. That meeting is scheduled for June 23rd. So if that's not already on your calendars, please note it for your awareness so that we can ensure we still have quorum to get that case heard in a timely fashion.
10 a.m. as well.
10 a.m. Yes, is that correct, Juan?
So.
Okay.
Double check.
We usually try to keep them at the same time and on the same day of the week if we can. Okay, now moving into our very last action item of the day. I have a couple of certificates here. So we always like to thank the members of our committees for their service to the committee. And we have a couple of people to issue thanks to today. First, and unfortunately not here today, but Chief Day often is occupied, right, and has a designee that appears for him at these committee meetings, and that would be Chris Jovic. So he is retired or retiring in the very near future. However, has served pretty diligently with this committee and routinely appears to hear our cases on behalf of Chief Day. So we will make sure to send the certificate of our appreciation and a letter to him, just illustrating how much we appreciate his willingness not only to step up to the committee, but on another person's behalf. And we know that it's a lot of work. We send you guys away with a lot of material, so we certainly appreciate it. And someone who is here today, who has served for 4 years on this committee and who I'm very sad to see not be able to be on PPC anymore, is Rob Wood. So Rob has been a very diligent PPC member. Luckily, now I got you for one more year on ARC, so you're not going anywhere that soon. but also just helps DPSST out in a variety of capacities as a trainer. And as I'm sure you all know, it's just a really excellent and highly valued member of the public safety community. Rob, thank you so much for everything you've done for this committee and for your continued service on ARC.
I just add, Rob, I've appreciated as a public member, you're always prepared. You read the material, you watch the videos, you know the cases inside and out. I know it takes a lot of your volunteer time to do that. And I've really appreciated it. When people are not talking, I always look to you to say something. I just know I know you have thoughts, and I appreciate that. That's why we're here. And so as the chair, you have filled in awkward silence a lot. This committee is much better now, I think, about talking, because I started calling on people, but I've really appreciated you being on the board. Sad to see you go.
Thank you for that. 4 years ago, I didn't know exactly what I was getting into, and you get these volumes of things, and that's a heavy responsibility, not only protecting the public from bad players, but protecting someone's career like Budworth today. It's difficult, and I'm honored to sit with all of you, that you hold your peoples to such high standards. I think that's great. It's really good. So thank you.
Thank you, Rob. And I guess on that note, I would also just like to thank everybody for your participation today, for wading through these heavy volumes of books, and for always giving us the best of your discussion and deliberation. These are not easy cases, and every single one of them, as we saw today, is very unique. The work you do is really, really important. So thank you all.
Okay. All right, next policy committee, August 20th, 10 a.m. Well, actually not.
June 20th.
It's on a seat, sorry. I will be on that one, apparently. June 23rd.